They're almost, well, maybe this would be a good transition. They're almost as political as our January 6th judges are.
Let's go there. I mean, I think people have also had it with our, with the Russia stuff. I mean, it's a sensitive topic. People, it's divisive, even among our community, Robert. Jan 6. Okay, so we've had now, I didn't know, there's a bunch of convictions that are sort of going on under the radar or guilty pleas, but we had a big conviction this week. I'm going to forget the person's name. It'll come in a second. An individual who was found guilty on 5-6 charges, obstructing congressional hearings, parading around a Capitol Hill, like stupid charges. The interfering with government proceedings was the big charge, the felony, and then stealing the coat rack. Robert, we've talked about it before, but it's worth repeating. The charge of interfering with congressional hearings, I forget what it's called exactly, but explain what the essence, or in theory, what the historical raison d'être of that provision of law was. What does it include, and why, according to some, does it not include protest?
Well, I mean, the obstruction statute's already been interpreted by another federal judge to not apply to this case, period, because it's being misapplied and it was meant, all the obstruction related, and all of these are mostly derivations of that. You have the basic misdemeanor criminal trespass and some of those. There, the issue is whether or not they thought they had authority to be where they were at. But as to all the obstruction type charges, you have to show, the goal of those was somebody that literally, using fraudulent mechanisms, made it impossible for Congress to perform its duties. So it was submitting a fraudulent document, forging a document, perjured testimony, suborning perjured testimony, witness intimidation, these kind of things. Very analogous to obstructing a judicial proceeding. And just objecting is not obstructing. And the parts of the legal left have been trying to make that argument for 5 years now, that just objecting is somehow magically obstructing. If you don't let me do what I want to have happen, then you're obstructing me criminally. That's not criminal obstruction. Criminal obstruction is limited to a very small category of groups and people and institutions. And so the criminal trespass cases are a little bit different. That's just about what they knew at the time they went in. But all these obstruction related charges are problematic because, again, a court has said that they can't be charged with obstruction, and you have other DC courts convicting people based on obstruction. I mean, it shows the problem, and it means the higher courts are going to have to get involved. I think at some point the higher courts will agree with the district court that said this is not what the statute means under the rule of lenity, and will determine that these criminal charges are not valid. Are you there, Viva? Oh, he's reloading. So what happened to this one individual defendant was he got a ridiculous sentence or ridiculous language used by the judge that showed his bias against Trump in particular. And what I've been arguing is that you can't get an impartial jury pool in the District of Columbia. This is now 3 jury trials in a row that prove that. Jurors kind of joking about how it took them longer to order lunch than it did to convict somebody of a bunch of charges, including charges that they legally could not even be charged with. Gives you a sense of how serious these jurors take their duties, which is to say not seriously. And you have judges on top of that ruling that taking personal attacks against Trump, which is what I've said from the get-go, these District of Columbia judges feel too personally attached to this case. They cannot be impartial, and they're proving it in live time and now bragging about it on the record.
Robert, I don't know how much of what you just said everyone got. Did everyone hear Robert? I know I was disappeared for a second because I'm tethering off my phone. Chat, let me know. 1, did you hear what Robert just said? And 2, if you didn't. Let's see if we got that. Okay, you heard Robert. Good. Fantastic. Robert, I know the answer to the question, so it was less for me and more for everyone else. Okay, good. His name was Dustin Thompson. I'm not going back to my phone for the rest of the night, guys. I'm sorry. Okay, so now I understood that part because, and if this is how it's to be interpreted, Robert, and if you said it when I was blacked out, this will go for interfering with the Kavanaugh proceedings. Did you mention that?
Oh, yeah. Well, I mean, I didn't, but I mean, in other words, they should have only been charged with trespass for those who really thought what they were doing was illegal and who committed some sort of violent act that was not in self-defense. There's a trial coming up that one person that was violent towards police is Capitol Police is saying it was in self-defense because they were physically attacking me and others around me. So we'll see how that goes. But the one acquittal was by a Trump appointee judge who just followed the facts of the law. These other judges can't. It's quite clear. These comments are such that they can't, and they won't.
And that's what I want. I don't know if people saying unsubscribe is a joke, but see you're lost. I think that's a joke. When people are going to accuse you, Robert, you're going to say, okay, look, the Trump appointed judge got it right. The other judges didn't. When you listen to the rationale or the statements attributed to the judges, this judge in this particular case, his name was Dustin Thompson, convicted, referred to Trump as a charlatan who was only interested in retaining power and is tearing the country apart. This is what the judge is saying. So I don't care if you believe it. I actually don't even care if the judge in his heart of hearts believes it. You can't call the former president a charlatan in a judgment in the context of a file where you're going to be sentencing the defendant. So if anybody thinks it's your bias, I'm going to say that that's their bias. I didn't know who the other judge was who acquitted the individual. I just knew that it made a load more sense than this conviction and what the judge said. A charlatan who is, who's only interested in power and tearing the country apart. But and this is the judge who's going to be sentencing this guy, and I don't think it looks good. But
no, it doesn't. I mean, we'll see how. I mean, we'll see if they can get a fair verdict or fair jury for the Sussman case, because they're the politics on the opposite side, and there the defendant has a very friendly jury pool, but there the judge denied his motion to dismiss. This is a Russiagate, Spygate case. Now, I think Durham is basically still cleaning up in protecting the CIA, protecting the FBI, rather than actually going after them by trying to shift the blame to the lower group of lawyers who are associated with the Clinton campaign. But what is detailed in the motion to dismiss and the denial of it and the various responses and motions in limine is that what some of us said from day one is proven true by Durham's inquiry investigation. And in fact, what's amazing is the CIA knew it. CIA's own analyst internal notes said that this is made up, said this appears to be user-created, generated data. This is not independently confirmed, gathered data. It's just fiction. It's fabrication. Now, how did Robert Mueller not figure that out in 2 years of his, isn't that interesting? Somehow Durham figures it out, but Robert Mueller never got around to that somehow, even though the CIA's, again, internal notes from 2017 said this thing is bogus. And yet Brennan was going out there lying to people. Adam Schiff was going out there lying to people. Clapper was going out there lying to people. Comey was going out there lying to people. Their own internal notes knew it was bogus from day one. And yet the only people that will likely pay any price, if anyone, would be Sussman. We know how the same DC judges let Kleinsmith walk, serve no time at all for deliberately perjuring and obstructing an actual investigation from a position of federal law enforcement power. And then the DC bar relicensed him right away within a year. It tells you how corrupt our DC is. We need to abolish the District of Columbia as a political jurisdiction, period. They are not capable of impartial justice. They will never be capable of impartial justice. Incorporate them into Maryland or someplace. But incorporate them in another state. It was a bad idea to create a separate district. It was always a bad idea. And it's where all the political cases have to go now. And what we have is one side dominates it. I mean, they have more the anti-Trump side of the aisle has more control over D.C. than Bull Connor had over Birmingham. And yet you have as good a chance of getting justice there as Martin Luther King would have in a 1960s Birmingham juror. And so it's an embarrassment. It's an outrage, but it's one that will keep going on until somebody fixes it. Republicans in Congress say they're going to get around to the Whitmer case this week. We'll see. Why weren't they around on the Whitmer and the January 6 cases for years? But it's embarrassing what we're witnessing out of D.C. Hopefully, it's clear Sussman lied. They've got documentary proof, textual proof, his own written text, his own written words, his own billing statements, his own emails. If he's not convicted, that will be a pure jury nullification just because they hate Trump in D.C. We'll find out.
Well, now people are asking, shouldn't a judge showing obvious personal and political bias be grounds for mistrial? And the chat before that, which said, can the judge, Reggie Walton, be impeached for violation of judicial oath? I mean, I know the answer to that is no.
Generally, no. I mean, I'm generally, as anyone that's followed knows, I'm a skeptic of using impeachment. However, when judges get this far out of line, even though you're not going to convict them, there needs to be this issue needs to be put into highlight. And pursuing impeachment proceeding, a violation of judicial oath is grounds for impeachment. And Samuel Chase was impeached the way back, ultimately not convicted, but impeached because of his political bias. And even though he was not removed from the court, and I agreed with him not being removed from the court, it sent a message, and judges started backing off overtly politicized manipulation of the law in cases. So that would be a reason to do it, is there haven't been enough of these. They only go after notoriously corrupt judges and if you dig deeper, you find out that that's not usually the real reason either. But that's a story for a hush hush at vivabarneslaw.locals.com. But I think they should start looking at these, because some of these judges' behavior is really outrageous. It's discrediting the rule of law, it's discrediting the institutions of the judiciary, and it's dishonoring the Constitution and it's disobeying the oath they took.
I mean, this would have been a perfect segue into the seizure of Victor Vexelberg's yacht. Well, maybe we'll get there just in a second, but first things first. So the judge who issues these very, very like over the top statements is going to be sentencing this guy. One of the jurors in the trial who just convicted him immediately runs to the press under the condition of anonymity to say, we were laughing under our breath when he gave his excuse. Trump is not on trial, but we all agree that Trump is guilty in this narrative. I mean, the system is broken.
The jury selection is a joke. And it was what I've said from day one, is it was impossible for these judges to be impartial. It's impossible to get an impartial jury pool out of the District of Columbia. That is being proven in abundance. And people just need to keep hammering it in the court of public opinion. People like Matt Gaetz, people like who's been a victim of corrupt justice actions in the past, people like Marjorie Taylor Greene, people like Paul Gosar, people like Thomas Massie, people like Madison Cawthorn, others need to start elevating some of these judges for at least proposals of impeachment proceedings to investigate whether or not they have violated their oath, because there just needs to be more public attention to it. Because although the D.C. Court of Appeals is a waste of space, unless the U.S. Supreme Court steps in and does something, we are seeing openly politicized Stalin-style show trials convicting people based on things that even other D.C. judges admit are not a crime, and being sentenced to absurd sentence results that are politically prejudicial, preferential. I mean, again, just between the Kleinsmith case and these cases, and we'll see with the Sussman case, the disparity is absurd. But they are so oblivious. They live in such an internal bubble. They're like the warmongers. They live in a tiny bubble. They don't understand how the rest of the world sees what they're doing. I mean, there's a reason why many countries around the world, including Russia, but not limited to it, cited the January 6 cases as an example of America's overt political manipulation of its judicial proceedings to target its political adversaries.
That's the jury, that's the judge. What about the defense attorney? Like, I know now I might be looking for conspiracy where there isn't, but the defense strategy for this guy, Dustin Thompson, who was just convicted, his defense consisted not of the defense that we just saw work in another case, in the one where the guy was acquitted, whereas they let us in. I didn't know it was wrong to be there. I mean, stealing the coat rack, you know it's wrong, but if that's the minor charge on which he gets convicted versus the major charge of obstructing Congress, you know, another guy literally just succeeded on that defense. The defense in this case says, our best defense is Trump told me to do it. I was following presidential orders. I mean, I read that defense and I think either the defendant is an idiot and went along with it or asked for it, or these defense attorneys are absolute idiots at best, and maybe, I don't want to say like sleeper moles at worst, but I had the thought. What do you say about the defense strategy? Plead as a defense, the president told me to do it.
Yeah, I mean, I think that's a tendency of liberal public defense lawyers in the criminal defense bar. that rather than doing a meaningful, sensible defense, a lot of these cases they haven't demanded real discovery. For example, there's to my knowledge, it may have happened in some other cases, but at least in some of the cases, they've failed to demand everything related to QAnon, and they should, because again, I think there's an entrapment angle here that was exposed in the Whitmer case that's present, and that would be politically embarrassing for the government if they dug deep into the QAnon phenomenon, how much of it was government because again, the QAnon boards and the people from the QAnon following were saying that the government wanted you to raid the Capitol for some of these people. So I have no doubt some of them thought they were acting on the government's behalf through secret messages from QAnon. I also have no doubts that QAnon was a government operation. Look at what happened with the Whitmer case. It ended up even worse than I thought it would be, in the sense of, I didn't know the government was the FBI was backsetting up fake militias again, just like they did with Operation PatCon. People can research when that started and when Oklahoma City happened, and put some things together. Again, you can find that at a hush hush at vivabarneslaw.locals.com. But it's disturbing. Good, but here's where the court of public opinion matters. Trump has said if elected, he will pardon all of them. Anyone that gets convicted, he'll pardon. And so that's because the court of public opinion has got to someone like Trump. And given where things are going, chances that Trump is back in the White House, despite all of these efforts to railroad his supporters and him, is growing by the day.
This is one of those examples, one of those situations where I look back at Blackwater and how could there have been a pardon? How could it have been such a politicized prosecution to warrant a pardon? I've lived through it. Whether or not these January 6th defendants deserve something, okay, I think some of them deserve something. QAnon shaman did not deserve 4 years in jail for what he did. He didn't. I don't care. And call me whatever you want. Maybe 30 days, maybe 60 days. He did not deserve 4 years in jail. This guy who stole the coat rack, found guilty of a felony, maximum sentence 20 years. He's gonna get 5 years. I think he's gonna get 5 years. And I can understand now he might have deserved something. Had the system worked the way it ought to have, he would have gotten 30 days plus probation. I now understand how pardons are warranted. And in 3 years, whatever, when Trump comes in and everyone's forgotten about this, I'm going to say, I lived through it. I remembered it. I paid attention. It is one of those cases where I now understand it. But Robert,
was what the great governor, Big Jim, sorry, go ahead.
No, what were you going to say?
I was saying, well, it's the reason why the great governor of Alabama, Big Jim Folsom, used to pardon about half the people each year. So he said, with as bad as Alabama's criminal justice system is, there's at least a 50-50 chance they're innocent. So he was an old school populist. He drank some mountain water on TV once. It might not have been mountain water, which didn't go over well in Alabama. But he invited Adam Clayton Powell down back during the middle of the civil rights movement. Big Jim was the real deal. I'm a big fan. The only thing maybe worse than having to deal with the DC court system and serving 4 years or however ridiculous sentences are is, you could be married to Amber Heard.